What if the citizenship you earned years ago is now being questioned by the same government that granted it to you? This is a fear that is rapidly spreading among naturalized citizens over the age of 70, and the concern is intensifying as reports emerge of increased denaturalization reviews targeting elderly immigrants who became United States citizens decades ago. The reason this story is gaining so much attention is because for most naturalized citizens, the oath ceremony represented the final step in a long and difficult journey. After years of maintaining lawful permanent resident status, passing interviews, completing background checks, and demonstrating good moral character, they raised their right hand and pledged allegiance to the United States. For many, that moment was supposed to mark the end of immigration uncertainty forever. But what is now being reported suggests that for some seniors, that certainty may no longer exist. Sources familiar with the matter indicate that the Department of Justice, in coordination with the Department of Homeland Security, has expanded its denaturalization efforts in recent months. While denaturalization is not new, the scope and focus of the current initiative appear to have shifted in ways that are affecting elderly naturalized citizens who obtained their citizenship many years ago. To understand how this is possible, you need to understand what denaturalization actually means under United States law. Citizenship obtained through naturalization can be revoked if it is later determined that the individual was not actually eligible at the time of naturalization, or that they obtained citizenship through fraud, misrepresentation, or concealment of material facts. This is a legal process that typically requires a civil or criminal proceeding in federal court. Historically, denaturalization was relatively rare and focused primarily on serious cases involving war criminals, terrorists, or individuals who committed significant fraud. However, reports suggest that the current administration has significantly increased resources dedicated to identifying and pursuing denaturalization cases. The concern among senior citizens is that cases from 20, 30, or even 40 years ago are now being reopened and reviewed with fresh scrutiny. Immigration attorneys report that elderly clients have received letters or visits from federal investigators asking questions about their original naturalization applications. In some cases, the questions involve discrepancies in old records, inconsistencies in how names were spelled or translated, or issues with the documentation that was submitted decades ago. For seniors who completed their naturalization process long before digital records existed, these inquiries can be particularly frightening. Many no longer have copies of the documents they submitted. Some may not clearly remember details from interviews that took place when they were much younger, and others may have difficulty understanding what is being asked of them due to age-related cognitive changes or language barriers. What makes this situation especially concerning is that the standards being applied now may be stricter than those that were applied at the time of original naturalization practices that were once considered acceptable or that were overlooked by adjudicators in earlier decades, may now be viewed as disqualifying errors. For example, minor discrepancies in birth dates, name spellings, or travel history that were not flagged during the original process could now be characterized as misrepresentations. Sources indicate that DHS has been using advanced data matching technology to cross-reference old naturalization records with other government databases. This has reportedly led to the identification of cases where information provided during naturalization does not perfectly align with records held by other agencies. While these discrepancies may have innocent explanations, they are triggering reviews that can result in formal denaturalization proceedings. The emotional toll on affected seniors cannot be overstated. Many of these individuals have lived as United States citizens for longer than they lived in their countries of birth. They have raised American children and grandchildren. They have paid taxes, served in their communities, and contributed to the fabric of American society. The prospect of having their citizenship revoked at this stage of life is not just a legal matter, but a profound personal crisis. Advocacy organizations have raised alarms about the fairness of this process. They argue that pursuing denaturalization against elderly individuals for minor discrepancies in decades-old records is disproportionate and unjust. They also point out that many of these seniors may not have access to adequate legal representation. Denaturalization cases are complex federal proceedings, and defending against them requires experienced immigration attorneys who specialize in this area. For seniors who receive inquiries or notices related to their naturalization, experts strongly recommend seeking legal assistance immediately. It is important not to ignore any correspondence from DHS, USCIS, or the Department of Justice. Seniors should avoid making statements or signing documents without first consulting with an attorney. Family members should also be aware of this issue and should help elderly relatives monitor their mail for any official government correspondence. At the institutional level, DHS has stated that its denaturalization efforts are focused on protecting the integrity of the immigration system and ensuring that citizenship is not obtained through fraud. Officials have emphasized that the process includes due process protections and that individuals have the right to defend themselves in court. However, critics argue that the practical reality is that elderly immigrants may lack the resources and ability to mount an effective legal defense. The situation remains uncertain, and it is not clear how many seniors may ultimately be affected. But the message spreading through immigrant communities is clear. Naturalization may no longer be the permanent protection it was once believed to be. For seniors who became citizens decades ago, this is a deeply unsettling moment. The path forward requires vigilance, preparation, and access to qualified legal counsel. This is a developing story, and further updates may emerge as more cases come to light and as legal challenges proceed through the federal court system.